more written form. It's just my personal view. So it's just a view. You can consider it, Mr. Tommy Joe. Well, Mr. Chairman, and I read the English version. Anything the publication of which. So it's not just anything really. In English, it means that it's some form, something that's published, or some form of publication. So it seems that the Chinese version covers a wider scope, but whereas in English, it's restricted to anything the publication of which is my understanding correct. Anything. Does it generally refer to anything that has to do with publication or publishing? Drafting division? The publication of which actually refers to the publishing of something, and publishing that something may constitute an offense endangering national security, then it cannot be posted. So you have to, read in context as for this provision what are prohibited articles. So if it's something that you publish that may constitute an offense endangering national security, then they ask that something cannot be posted. So it is actually consistent with the Chinese version. Because in Chinese, we have 发布, which means publish. But Chinese 发布 in English is publication. If you ask me, with my limited English knowledge, 发布 should be something about publicizing. But then in English, publication is about items to be posted. So that's the way I see it when I read the English version. I don't mind about the word anything. I'm just saying publication in English and in Chinese is 发布 to me, which is publicizing, but it's not an exact equivalent. So if I just read the English and without reading the Chinese, it's fine. But when I read both the Chinese and the English versions, it seems they are not the same thing. I'm not a law draftsman, of course. So I'm just saying that I see a difference here. That's a comment of Mr. Zheng. Any response, please? Thank you, Mr. Zheng. We'll go back and consider it further. Thank you. Mr. Jeffrey Lam, can you repeat what you said, because your microphone was not on? Now, publication, 发布 means, information, publishing information, and so it's not publishing something. And so that's why I refer to the word anything. It's exactly because you use the word publish in Chinese, 发布. Okay, so again, a comment. Please consider it as well. Ms. Carmen Can. Thank you, Mr. Chairman. The H here is to replace the original H. So this is the Post Office Ordinance. And here we are looking at an amendment to Section 32 of the Ordinance, prohibited articles. So articles that cannot be posted. H is anything the publication of which there's an offense endangering. Originally, it's any seditious publication within the meaning of any enactment relating to sedition, because here we're talking about posting items, so it must be publications then. And then originally it's about seditious publication, the meaning of which is related to any enactment relating to the sedition. But now we are changing it to anything the publication of which would constitute an offense endangering national security. So in Chinese we say 任何嘢 anything, and then in written form is say 东西, but this means also thing. Personally, I don't have any strong views on the word thing or anything, but here this section is about items to be posted, and that's why the term publication is used. In Chinese is 发布. Before we talk about the publishing of false or misleading information, at the time the term 发布, I asked about it, And I suggested that to make it clear, we should perhaps give a definition to the term fatbo or publish. And here, what we see is that is only publication we're referring to. Of course, that may have nothing to that will affect 43(1) in relation to the Article 23 legislation, but if we don't use publication, then and then here we're talking about espionage and publishing of information. So would it cause any limitation? Because I'm using this provision, I just trying to bring out the point that I think the term fatbo or publish is not clear enough. Well, perhaps we will also consider about the Chinese and English words to be used for the term fatbo or publish. Okay, then, if there are no other points, let's go to clause 114.7. It's part 9, division 17. Yes, clause 147, and it's page 233 in the English version of the marked up copy. That is a section is to amend section 48, conspiracy in relation to trade disputes. Now in section 48 bracket 2, it says that if an act done in pursuance of an agreement is in contemplation or furtherance of a trade dispute is not actionable. And then in sub bracket or subsection 4, originally that's the words sedition or any offense against the state or the sovereign. So we're going to adapt that and improve the construction. So we change it to any offense endangering national security. Thank you. Mr. Carmen Ken. Now, in the trade unions ordinance, there is this proposed amendment. Is it just about the scope of the offense? And so we wanted to cover any events endangering national security. That's the purpose of the amendment, right? And secondly, it's the amendment strikes out the words the state or the sovereign. I think it's the same problem we brought up yesterday. You know, terms like the state or the sovereign in this whole amendment exercise, I understand it is about the adaptation of laws in these statutes. But then with the national security bill, I don't wish to see again the term state when it's not referring to the People's Republic of China. So can you confirm that at least for this legislative exercise, we won't leave out any term state or the sovereign? So in this exercise, all these terms, the state or the sovereign, should have been removed. Can you confirm that's the case? Sovereign shouldn't appear in any other provisions in relation to related amendments. Thank you. So you mean that this is the only provision that requires adaptation, right? So I'm saying that for the entire Safeguarding National Security Bill, right? I think no, they're referring to the Trade Unions Ordinance. Apart from this provision, there's no need to adapt to conduct adaptation for other provisions in the Trade Unions Ordinance. Is that what you meant? Yes, Mr. Chairman. That's why I want the administration to confirm it's not just about this clause that for divisions 2 to subdivisions 2 to subdivision 9, we refer to corresponding amendments to existing ordinances. So it's part 9 in the various subdivisions. So here, I just put simply, I just don't want to see the term the state, which doesn't refer to our country, or a term like sovereign to appear anymore in provisions relating to safeguarding national security. I don't want to see any provisions not adapted to that effect. That is. Let me tell you what my understanding of what Ms. Carmen Ken is saying. Now, for the ordinances that need to be amended in the context of safeguarding national security, then you should also do adaptation of law to those ordinances in one go. Yes, I fully follow what Ms. Can is saying. So your understanding is my understanding. Now, if we talk about adaptation of law, then it doesn't just cover provisions relating to national security, but then if it touches upon Article 23 legislation, then all the adaptation has been done. So the answer is yes. So you mean for provisions that need to be amended, then so in other words, adaptation of law relating to Article 23 has been done. But even when the provisions don't touch upon national security, we do have a plan for adaptation of law eventually. So you can take it this way, then, that for all provisions for safeguarding national security, adaptation of law is done. Now, it's been 27 years since the reunification. I'm sure that the DOJ will expedite that exercise, although it's been taking a long time. Yes, in fact, next, in the next panel meeting on administration of justice and legal services, we are going to report on the progress of adaptation of law. Mr. Standing. Now, I see that this is a matter of adaptation of law. And now you use the wordings, any offense endangering national security. In the original version, it involves the state or the sovereign. Now, I understand that in this bill, there are terms like a president of the country. So if you just use any offense endangering national security to cover everything, would you have left out anything? Can you explain that? Deputy Secretary for Security. Well, let me try to explain this adaptation. Now, any of sedition or any offense against the state or the sovereign. Now, in Part 2 of the Crimes Ordinance, you might recall for that whole subdivision, it's about ordinances of offenses against the king or queen. And when we started considering the Safeguarding National Security Bill, you might recall for parts 1 and 2, there's already replacement of terms like the Queen or treason-related offenses in the Crimes Ordinance. So here, for offense against the sovereign, that's been dealt with in Part 2 of adaptation of Part 2 of the Crimes Ordinance. This morning, we talked about the reference to treason. That's a similar matter, because in the past, when we look at such offenses, the scope is narrow. But now, when we look at the whole concept of safeguarding national security, so we're saying that here, for this provision, it shouldn't involve any offense endangering national security, because nowadays we talk about importance of national security, and we believe this replacement is appropriate, and that's why we're proposing this amendment. Thank you. Any other questions? Then we move on to Part 9, Division 29, page clause 181. Administration, please. Yes, clause 181. That's page 322 in the English version. Clause 181 is to amend the legislation publication ordinance, section 4, contents of database. Under 41A4 we under 4.1a, we're going to add 7, the Safeguarding National Security Ordinance. Any questions? Now, my own record shows that we have completed the clause-by-clause scrutiny of the bill. And these clerks also confirmed to me that we have already covered all clauses in the bill. Can I confirm the administration that to be the case? Is that correct? Yes, I confirm it's correct. Thank you. Mr. Tommy Jung. On part 5, I have a comment on part 9 rather as a whole. When will you allow me to give my views on that? We're coming to questions again. That is our exercise discretion to allow members to ask questions further. So far, only Reverend Peter Kuhn has indicated to the Deputy Chairman that he would like to apply to go back to questions again. Now, 4 members have pressed the button. I'll draw the line here, okay? Because we need to be efficient. Because all the other, issues have been considered before. Before I said I wouldn't allow members to revisit issues, but since some members have made the request, so I'm exercising my discretion to allow you to revisit certain issues or to ask questions again.
Mr. Jeffrey Lam, the so-called revisiting certain provisions, is it that only the 4 members so indicated could speak, or can everyone else speak as well? No, only 4 members who have indicated before. I've in fact drawn a line. I will not accept any other members' applications. Reverend Canon Peter Kuhn, perhaps you can kick off. About 23, subclause 3, or just tell us which page, which clause that you have a question on. Clause 23, C248 in the Chinese version or 249 in the English version. Which page of the bundle, please? Let me check. Is it page 20? Yes, page 20 in the Chinese version or at 28 in the English version. And I'm referring to clause 23, subclause 3. A person who, without reasonable excuse, possesses a publication that has a seditious intention commits an offense. Now, I put a question to the administration before. They gave me a proper reply. And yet, after that question, there were different interpretations put forward by other members. Even an ex-co member said that members of the public should have a good grasp of what it entails, so that to avoid bringing suspicion onto yourself, you should just throw away all seditious publications, so as not to waste your own time to bring up a case to the court. Now, I've been asked, say, if I have in my possession a publication that has a seditious intention, and yet I do not have any intent to commit a sedition, then am I committing an offense? I've been asked to ask this question on their behalf. So just to reassure the public and for the sake of clarity, please explain this point again. I will give 3 minutes to this question and answer included. SB, please. Reverend Kuhn just referred to a person without reasonable excuse possesses a publication that has a seditious intention. This is an offense. Now, here it doesn't prescribe the mens rea element expressly. And we also have the defense, reasonable excuse, so as to protect those without an intent. Now, if you take a look at clause 25, it refers to the reasonable excuse defense. I'm sorry. In fact, for the phrase reasonable excuse, it refers to a particular circumstance. This person may explain the particular circumstance to the court. The reasonable excuse provides for a special circumstance in which this defendant can explain to the court that there is reasonable excuse to do so. So this is a special circumstance for the court to consider. Secretary for Security. Well, I think the most important thing is that in possessing this publication that has a seditious intention, you must have knowledge that there is this intention. Without knowledge, you cannot establish intention of sedition. Just possessing a newspaper is not sufficient. We need to consider whether it has a seditious intention. We cannot just pinpoint a particular magazine or newspaper and claim that it has a seditious intention. Mr. Tommy Zhang. I'd like to comment on Part 9 of the bill. It's just a comment. I don't need a reply from the administration. About the related amendments. Well, as a layman to the legal profession, it's really difficult to make specific comments. But otherwise, I do like to raise a number of points as a layman. During the scrutiny of the bill, many members asked about some important requirements, such as a requirement to surrender travel document to be prescribed expressly for members of the public to understand easily. I understand that there are similar amendments, say for clause or section 68 under Part 9. It is said that a notice will be published in the Gazette and the amendment will take effect on the same date. In the future, members of the public may not be able to access the amendments to the relevant ordinances on the e-legislation website because of the lapse of time, such as some of the amendments to enhance the public's understanding on safeguarding national security. Some of these provisions have no consequence, and that the deletion or repealing these provisions will not affect the integrity of the bill. Now, there is also an amendment under the pensions ordinance, and that the pension amount may be suspended, cancelled, or reduced, and also for correctional services. There can be deregistration of directorship and other office-bearing positions because of contravention of this ordinance. A person may be deprived of the right to stand in an election. This is easy to remember. As for other issues, that may not be the case. In Division 7 of Part 9, Part 7 relates to measures targeting absconders. Part 8 also provides provide for different matters to safeguard national security. For clauses 107, 108, my comment is perhaps we should make reference to Parts 7 and Part 8, and that in the Safeguarding National Security Ordinance, a schedule should be included setting out other consequences to an individual who commits an offense under the ordinance other than the imprisonment and financial penalty. Just let me finish, Chairman. This is consistent with the object of the enactment of Article 23 legislation. Just a comment. I'd like to follow up on page 85 of the bundle. That's in the Chinese version. For absconders, after committing a national security offense, there is this requirement for the travel document to be revoked. Let's say, albeit a slim chance, this absconder might, in the end of the day, feel remorseful and return to Hong Kong. Now, I want to know whether this absconder will be able to apply for a Hong Kong SL travel document afresh, or whether this revocation is permanent. Ms. Siu, for the measures set out here, some of them are temporary. That means during the period of abscondment, the passport will be cancelled. However, this passport will not become automatically valid on their return. They do have the right to apply for this for a passport. That means after the Secretary for Security has cancelled this instruction, he may apply for a passport again. Mrs. Regina Ip, Clause 45, Part 4, Division 5. Definition of external intelligence organization. There are a number of bullet points. A, B, including intelligence work or subversion or sabotage of other countries or places. Why are we limiting ourselves to sabotage of other countries or places? The external intelligence organization may provide unlawful drilling for young people to engage in sabotaging activities. So why not just say endangering the national security of other countries or places? Why do you limit the scope to subversion or sabotage instead of broadly endangering national security? SB? There are two parts to this definition. The first one is intelligence work. I'd say that this is one of the well-established functions of an external intelligence organization. For the second part, we described some acts. We want to allow a flexible approach to be taken to tackle different forms of intelligence work. Well, of course, gathering intelligence is the staple of external intelligence organization, including even the involvement of state leaders. In 2019, we saw some organizations arranging for young people to receive intelligence training abroad, or perhaps indoctrinating them and encouraging them to advocate Hong Kong's independence. I think that instead of putting subversion or sabotage, you should use endangering national security. Right, the comment is noted. Legal advisor. You will take the floor. You can put questions relating to the bill as a whole. Thank you, Chairman, for giving me this opportunity to raise the concerns to the administration. We've spent a few days going through this lengthy bill, and there are a number of points we'd like to raise. We'd like to invite the administration to explain in greater detail to members and the public. Now we are sure, so that we are sure about the object and the purpose of the bill, and the administration can perhaps take this opportunity to make further clarifications. So without further ado, let me begin my line of questions. The first point I'd like to raise is in relation to some proposed offences in the bill. The necessary mens rea of these offences, in other words. So if I may refer you to page 5 of the bundle, one of the proposed offences, or rather one relevant element, is collusion with external force. This is something that I will touch on in a moment. Next, I'd like to refer members to the latter part of this bundle. That is proposed 52, that is collaborating with an external force. Be it colluding with an external force or collaborating with external force, my question is, in initiating the prosecution, is the prosecution required to prove actual knowledge? Say, if we go back to page 5 of the Chinese version, colluding with an external force, there are bullet points A to E, setting out the acts constituting collusion with an external force. Say, if this person is acting as an agent of the external force, knowing that this organization is an external force, then the limbs are met. So coming back to what I said for bullet points A to E under collaborating with external force, there is a different description. So my question is the prosecution required to prove actual knowledge? Or is it that when it comes to colluding or collaborating with external force, knowledge can be inferred? In other words, an inference can be made on the point of knowledge. For example, if this person participates in an activity organized by the external force, then one can infer that this person has knowledge of the external force. So that's about proposed clause 5 as well as the meaning under clause 52. All right, I think the questions are clear. Whether mens rea should be considered using common law principles or otherwise. DOJ. Thank you, Chairman. Thank you, Legal Advisor, for your questions. Clause 5 refers to the meaning of colluding with external force. It should be read with the proposed offenses in the later sections. And if this is read against the meaning of collaborating with external force in clause 52, the prosecution is required to prove actual knowledge. That means the party with which the person collaborates or colludes is an external force as defined by the bill. In fact, the Secretary for Justice explained this point in the previous meetings. One important reason is, as the chairman just now explained, there is common law principle of inferring the mens rea. The mens rea requirement may not be expressly prescribed, but these are serious offenses. The court usually would interpret the provision in such a way that there should be an inference of the knowledge that is mens rea. When it comes to colluding or collaborating with external force in these provisions, you will find that there is a requirement of actual knowledge. Say for 5C, the person does the act in cooperation with an external force. That means if the person has no idea of the identity of the other party, there is no cooperation to speak of. This is how it should be interpreted, and this is also in line with the common law principle. May I turn to the other question put by the legal advisor now? She asked whether an inference can be drawn on the person's knowledge. Under the common law principle, there is no principle of constructive knowledge. Some case authorities established the so-called constructive knowledge, but it has been overturned by other authorities, case authorities. No inference should be drawn in such a manner, such as collaborating with external force. That's page 70 of the English version of the bundle, or clause 54 on page 71. Presumption of doing acts on behalf of external force. I think the presumption is clearly spelled out here, how an inference is to be drawn. So I'll skip the explanation. In the absence of such a prescription, we cannot presume that this person has knowledge. It is for the prosecution to prove that.
Any follow-up? All right, we can move on to the next part, also about mens rea. My question would be on intention as for recklessness. For clause 15 and in page 14 of the marked up copy in the Chinese version. Members may note that in D2 of clause 15, insurrection, it says that if someone commits an offense in insurrection, one can be sentenced to life imprisonment. So I want to ask, for someone who has no intention but is reckless, one can be sentenced to life imprisonment. That will be a very harsh penalty. I want to ask what the policy intent of the administration is, and what are the justifications of the administration. Has the administration referred to any overseas laws? And if someone commits the offense while not having any intention, only being reckless, why would that person be subject to such penalties? Thank you. Deputy Secretary. Thank you. Let me answer this question. When we discussed this offense earlier, we explained that in common law, the standard for proving mens rea for insurrection is very high. And in Hong Kong, before, we did have instances where someone was reckless as to whether the sovereignty, unity, or territorial integrity of China or the public safety of the HKSAR as a whole would be endangered. And if there is such act to endanger these aspects of the country or the region, whether one has intent or is only being reckless, it does not really matter to us. That's why we put both of these scenarios in the clause so as to better protect national security. We did refer to overseas laws. For example, in Australia, there are national security offenses that would include recklessness. and they have quite harsh penalties. If there are sabotage activities conducted by overseas principals, the maximum penalty is 20 years of imprisonment. Thank you. Secretary for Justice. Thank you. Let me explain something basic in law. Mens rea is very easy, so one would have the intent to do something. But if one is reckless, one can say they have no intention, but they have committed this act, and that act is obviously wrong. So apart from including the element of intent, often in law it would also include recklessness. But then recklessness is different from carelessness. They are not equivalent. So basically, being reckless is turning a blind eye to the obvious. Basically, you may not believe someone has no intention when doing an act that is obviously wrong. But when they say they do not have the intent, we can still charge them with something because they are being reckless as to that act, whether that act is wrong. Well, correct me if I'm wrong. Apart from some summary offenses, all indictable offenses would require mens rea to be proved. So apart from having actual knowledge, that would be intent, that is also an element of recklessness. I believe in a case it was established that recklessness would require mens rea. I believe it was a case in the 1960s in the UK. So for indictable offenses, recklessness has always had its mens rea threshold established in common law. Chairman, your understanding is indeed correct. It has long been established in common law, and we do have a very high threshold for mens rea. And in enactments, we would often include recklessness as part of it. I want the public to understand that when one is reckless, it does not only mean that one is careless. I have a follow-up. If you do not include recklessness in this clause, if you only rely on recklessness in common law, and that would still be an element that the prosecution has to prove, correct? If you do not include it here in black and white, if you rely only on common law, the prosecution still has to prove that one either has the intention or is being reckless, correct? Mr. Lang, thank you. I understand that for most of the criminal offenses nowadays, we have to include the recklessness element in black and white. Otherwise, the court may not read it as an offense that would criminalize someone when someone is only being reckless. And for some long established criminal offenses in Hong Kong, for offenses that would involve life imprisonment, there is the section 60 and 63 of the Criminal Procedure Ordinance. It would be damage reckless as to whether damage will be caused to property or lives of people. And under this section, the maximum penalty is life imprisonment. So you can see that this is similar to the insurrection offense to a certain degree. If you would endanger someone's life, and that would be in the criminal procedure ordinance. And if you have endangered national security here in this proposed ordinance, one can be sentenced to life imprisonment. So for manslaughter, for example, one can be sentenced to life imprisonment, right? But this is a common law offense, right? So when proving this common law offense, is it the case that you can say that when one is being reckless, one can still be convicted of manslaughter, correct? Well, for manslaughter, it depends on the category. If there is a serious kind of recklessness, it's grossly negligent. If one is grossly negligent, then that would constitute such. And if someone is harmed, that is unlawful act manslaughter. It would depend on whether the defendant can foresee that the act that they did would cause harm to another individual, and that would constitute recklessness. Any follow-up from the legal advisor? Well, I will proceed on to a next question also related to recklessness, but this is different from my previous question. I want to ask about clause 30, and that would be page 28 of the marked up copy in the Chinese version. This clause we have looked at before, and I know that members will be quite familiar with this. I want to draw a comparison here. So in subclause 1b, it is said that if one has reasonable grounds to believe any information, document, or other article is or contains a state secret and with intent to endanger national security and without law authority acquires the information, document, or article, one will be sentenced to a 5-year imprisonment. And in 1A, it would be that one would have to know that it is or contains a state secret, but then one is reckless as to whether national security would be endangered. So basically, one wouldn't have the intention to endanger national security. So we have here the imprisonment term being 7 years. So if you compare subclause 1b and subclause 3b, when formulating these subclauses, what is the distinction between them? And why is there such a difference with the penalties imposed? Well, let me first talk about the recklessness part. If one has no lawful authority and acquires information, document, or article that contains or is a state secret, it would be an offense, obviously. And take insurrection as an example. We have a very high standard of proof, as said earlier. So we have a scenario here, basically. One is reckless as to whether national security would be endangered, and one has no lawful authority and has acquired the information, document, or article that is or contains state secret. I think compared whether someone who has the intent or someone who is only being reckless, we think that they would still be committing a same degree of offense, which is why we included the part for recklessness here in this clause. We have referred to Australian and UK laws for this. For Australia, for state secret offenses, if one is reckless as to whether national security would be endangered and the information is provided to an overseas principal, it is considered a very serious offense in Australia. The maximum penalty is a 25-year prison sentence. In the UK, the standard of proof is that one knows, or at least should know, that this is the case. And in National Security Act, Section 1 in the UK, if one obtains confidential information, so one knows or should know that it would endanger the interests of the UK. So this standard of proof is higher than that, lower than what we have here. Because being reckless, one has to know that there is a risk, but then one may not be aware of the actual risks. So this is the distinction. Thank you. Any follow-up? Let me put it this way. So when designing this proposed offense, under subclause 3b, your policy intent is that this subclause 3b would be a more serious offense than subclause 1b, even when one is reckless as to whether national security would be endangered and has, without lawful authority, acquired the information, document, or article containing or is a state secret. That is correct, and that is shown by the difference in penalties. Any follow-up? Thank you, Chair. I think we have dealt with the mens rea issue. My following questions relate to different parts of the bill. Let's go back to part 1 of the bill relating to the definition of external force, and that would be clause 6 and page 6 of the marked copy in the Chinese version. This has been discussed multiple times, but I have an observation. We can see that in 6(1)(a) to G, there is a description of what constitutes an external force, and these are all physical entities. It does not include, for example, an individual. So in the National Security Act of the UK, they have, for the definition of foreign power, individuals, including sovereign, king or queen, head of foreign state, and also authority responsible for administering affairs of an area. They would also include persons exercising functions of such an authority. So they have included individuals in the definition of foreign power. So this is my observation. Will the administration consider the existing definition of external force to be adequate, or would you consider including more elements? Thank you. Security Bureau. I'll let the Department of Justice colleague answer this question. Mr. Leung, thank you, legal advisor, for your question. For the definition of external force, we think that in 6(1)(a) and (b), that is a government of a foreign country and the authority of a region or place of an external place, if we understand it from a general meaning point of view, it would be an individual in the authority of a region or place of an external place, or a head of state, because the head of state would be the representative of the government of a foreign country. Members may also note that for individuals in Clause 6 of Clause 4, a related individual that would be included in the definition of external force, because there is such reference, especially in subclause 4b. It says that the government authority, political party, organization, or entity is in a position to exercise by virtue of other factors substantial control over the individual. And that would also include the element of an individual. Any follow-up from the legal advisor?
Another clause. Unlawful drilling. Clause 13. Or page 10 in the Chinese version of the marked up copy. Clause 13, subclause 5. Specified act. Then clause para C and E, that is whether that constitutes an offense. And if it comes under clause subclause for offenses acts in subclause 3 and 4, if they fall under subclause 5, then they don't apply anymore. So let's say a person, for humanitarian grounds or for official duties, he attends military drilling, say organized by the Red Cross. And then for subclause 5A to F, it seems, reading from the text, it won't cover us this scenario I just mentioned. So in other words, we consider exceptions. That is, if someone takes part in activities of this sort, then under the bill, it will not constitute unlawful drilling. And the provision, the way it is worded now, it seems that there is no defense clause. Of course, we're not saying that it can be used as a defense, but I'm asking whether you have consideration for this side of scenario. Well, let's say if someone takes part in activities of the Red Cross, could that be an exception, or could that be used as a defense? Security Bureau. Thank you, Chairman. So here we're on clause 13 bracket 3 and 4. Here we're talking about unlawful drilling. Now we're talking about the involvement of external forces or drilling provided by external forces. And clause 13, here we mentioned specified drilling. And in particular, we're talking about the use of weapons in the drilling. And there are exceptions. And also it includes some military training. That is clause 13.8 is specified, that is spelled out there. And then legal advisor just asked about, providing humanitarian support or exception or defense for obligations performed by, say, the Red Cross and so on. Now, we've referred to the similar provision in Australia. Say, a humanitarian training provided to an army may be considered military training. That's their concept anyway. And so, therefore, they provide defense. But if these organizations are actually giving training in the use of weapons, then it's not included in drilling. So if we take that scenario and compare it to our bill, specified drilling here we have. So for international organizations, if they provide humanitarian training on humanitarian grounds, actually it won't even fall under this clause. So that's why there's no need to provide a defense indemnity. And then for these international organizations, they could still carry out their usual activities. These activities won't be affected. Now, so for clause 13 bracket 5, do we need to include more scenarios that the clause does not apply? Because here we're using a non-exhaustive approach in drafting this provision. And we've already stated at the beginning of the provision that it's not covered here. Or then the Secretary for Security or the Commissioner of Police may, for special circumstances, having regard to the actual needs, give such approval or consent. So we believe that it's a better way to deal with exceptional cases. Legal advice, are any other questions, please? The next two questions have to do with seditious intention or offenses related to seditious intention. Clause 24 of the bill. Now here, there's a provision for if there are offenses related to seditious intention and their legal proceedings, there is a need to prove that the intention of inciting others or causing public disorder. So in our discussion, we talk about that and learn from the administration. This provision is so designed to take into account the latest Court of Appeal ruling on case. And yes, I follow that. But can the administration explain further? Now, under the laws of Hong Kong, in the design of this provision, you say there's no need to prove intention of using violence. Now, are there any other laws in Hong Kong that for a similar arrangement? That is, say, in Hong Kong, there is no need to prove that. Or so in future, when the prosecution produces proof, they don't have the burden of proof in this sense to prove the intention here. So rather, I'd like to ask the administration whether you could explain further that this intention to incite violence is not a necessary element. Let me help out my colleague here. Now, I get your point, legal advisor. In the law, of course, we're referring to a case precedent of the Court of Appeal. Now, in that case precedent and previous case precedents, there is explanation why in the case of Hong Kong, there is no need to prove the intention to incite violence or to cause public disorder. Why? Because we've learned from the experience in 2019, we went through the Black Clad violence and the Hong Kong version of color revolutions. Have we seen seditious publications? In those publications, they did not encourage people to use violence, but then the intention of the publication is to incite people in Hong Kong to go against the country and the SAR government. So the purpose of the publication is to sow hatred in the minds of people. And so that's why we have considered the unique situation in Hong Kong. And it's also based on what happened in the past few years. So different levels of court also consider it. Apart from interpreting the law, we also have to consider the unique situation in Hong Kong and what happened in Hong Kong. And I'm sure this is still fresh in everybody's mind. Animation or cartoons, and there's no mention of use of violence, but then in those cartoons, you might recall, they try to demonize our country and the SL government. And then when young children read those cartoons, what would they think? They would think, well, this country is, they will resent this country. They may hate this country. And there may even be disaffection incited in a way. So, of course, this is a way to destabilize a country. So in Hong Kong, we have to consider court rulings and case precedents, but at the same time, we have had painful experience and we've learned our lessons, and we believe this is the appropriate approach. So that's court ruling as well as our own experience in Hong Kong. Mr. Low? Thank you, Chair. If I may add, just now, SJ mentioned the experience we had, and that shows there is need for this. And then in the recent Court of Appeal ruling, the European Human Rights Court and the UK Court on Human Rights both said that there's no need to have actual act of violence before national security is endangered. So and so when we put restriction on the freedom of speech to some degree, it doesn't need to include the element of violence for us to do so. Also, we have therefore considered all these other experiences, and the principle is therefore reflected here. In other words, violence is not a precondition. And we believe then under the circumstance, it is appropriate for us to restrict certain rights. Anything else, please? Any follow-up? Any other questions then, or other points, legal advisor? Yes. It's still to do with seditious intention. Clause 26. It's about 26, subclause 3. If the publication that has a seditious intention is not visible from a public place, and if the following conditions are met, then 1A may apply, that is the power to enter premises. One, with the prior permission of the occupier of the premises or place, or acting in accordance with a warrant. Now, under the circumstance, say it's a domestic premise, and the publication, well, yes, it's in a private property, but then it is visible from a public place. So when it comes to law enforcement, does it mean that you still need to get a warrant first? Because if we consider subclause 3, then for private premises, there's a seditious publication visible from a public place, and in that circumstance, how do we handle it? Of course, we must also make sure we comply with Article 29 of the Basic Law. Mr. Low, thank you, Chair, and thank you, Legal Advisor, for the question. Now, for a case precedence in Hong Kong, the Court of Appeal has ruled that if there are certain powers, and these powers involve entry to premises, both domestic or non-domestic, the purpose is for criminal investigation or gathering of evidence, then in general, there is need to apply for a warrant. But in this clause, the powers are slightly different. Clause 26 makes reference to Section 14 of the Crimes Ordinance. Now, if it's visible from a public place, it's not visible from a public place, then there is need to obtain the permission of the occupier or a warrant issued by a magistrate. But if it's seditious publication visible from a public place, then there is no need to obtain prior permission or warrant, because for publication that's seditious, that means it has a seditious effect. And if the publication is visible from a public place, then definitely it constitutes a risk of endangering national security. It might incite people to act violently or not to comply with certain laws of Hong Kong. So that's why there's a need to empower law enforcement officers to enter the premises as soon as possible to remove the publication. So there is no need to apply for a warrant in advance. But we must stress that we are giving very limited powers to law enforcement officers. First, this is not for the purpose of criminal investigation or for a search in the premises. It's primarily for law enforcement officers to take targeted action to remove seditious publications visible from a public place. So therefore, for Clause 26 is necessary for ensuring safeguarding national security. Is also in line with Article 29 of the Basic Law. Thank you. Any follow-up, please? Any other questions? Next, then, we move on to Part 4 of the bill. State secrets, the definition of state secrets. Now, first, I'd like to clarify a point. From A to G, sorry, it's page 26 of the Chinese marked up copy. It's clause 28. That means interpretation in part 4. Now here, there is the definition for state secret. And there's a series of descriptions saying that if certain conditions are met, then that information will be regarded as state secret. It's from A to G. And so for these secrets in A to G, maybe at a certain time, the information may have been published, and that means the information is in the public domain. Will they then become non-state secret in accordance with this clause? In that case, is it necessary to state clearly in the bill that if a certain secret is subsequently published or made public, then it is no longer state secret? In that case, it will be easier for journalists to follow the bill. That is, when they do any news reporting or investigate any issue, if they know that the information is already in the public domain, then they know it will no longer be considered state secret under the bill. Secretary, yes, let me take the question. The definition of state secret, there are 7 areas covered, as you mentioned, in the interpretation. Also, there's the element of without lawful authority to disclose, or there is likelihood of it endangering national security. Now, if something is put in the public domain, it actually won't change the nature of that information of being state secret. It's just that someone puts it in the public domain, and then how many have actually seen it in the public domain? Or maybe then we invoke Article 43 of the National Security Law to remove that information from the public domain. So whether it's in the public domain or not has nothing to do with the nature of state secret. It's not an excuse just because it's been put in the public domain because someone may have read it. So it's declassified. It's no longer state secret. So that's not going to happen. Thank you. Any follow-up or other questions then? Next. Clause 33. It's about unlawful disclosure. Oh, sorry. I read it wrong. It's clause 35, rather. Unlawful disclosure of information that appears to be confidential matter. Now, I'm sure you would recall that we've had some discussion about this clause before. So I'd like to seek confirmation here. Now, if a person unlawfully discloses genuine secret or fake secret, then that person would have committed an offense under this clause. So can you confirm that to be the case?
Mr. Lau? Thank you, Chairman. I confirm that. So my next question is, as per the previous discussion, I'd like to add another question. How should we interpret this clause, unlawful disclosure of information that appears to be confidential matter vis-a-vis the common law offense of misconduct in public place? Public office. Well, in considering which charge should be laid, would the same basis be adopted, or is it that for these two offenses, one being this new offense, the other being the common law offense, will they become an alternative charge of one another? Who will take this question, Mr. Lau? Thank you, Chairman. Thank you, Legal Advisor. My understanding is this: for the misconduct in public office, it is a common law offense. It includes public bodies as well as the government. We're talking about serious misconduct involving the abuse of power. So in essence, it is not the same as the unlawful disclosure of information that appears to be confidential matter. They are different in two aspects. For the MIPO offense, government contractors are not included, and there is no element of intention to endanger national security. In some circumstances, if this specified person discloses information with an intent to endanger national security, it should be dealt with under the proposed offense. But of course, we also need to consider the actual circumstances of the case. As discussed before, if there is overlapping between the proposed offenses and the existing offenses or common law offenses, to avoid double jeopardy, we should refer to the prosecution code in order to go with the most suitable charge. Any other questions? Next, let me turn to part 6 about external interference in organizations engaging in activities endangering national security. Let me refer members to Clause 58, page 75 of the English version. The Secretary for Security may prohibit such organizations from operating in Hong Kong. My question for the administration is this. Secretary for Security may exercise his power to order or prohibit the operation of the organization in the HKSAR, and in doing so, Secretary may consider a number of things. Will you consider setting out in a non-exhaustive list things that the Secretary may consider, so that on reading Clause 58 on the Secretary's power to prohibit the operation of organizations, one will have an idea what the Secretary will take into account before exercising the power of prohibition? Yes. Thank you, Chairman. Thank you, Legal Advisor. Under Clause 58, Subclause 1, the Secretary for Security is empowered to prohibit the operation of an organization in order to safeguard national security. Now, there may be different scenarios. We need to have regard to the facts of the case and all circumstances. That means, first of all, we'll consider the basic law, the Bills of Rights Ordinance, in all the freedoms safeguarded, including the freedom of speech, etc. And there is also a clear definition of national security. We also consider the fact that the national security risks are ever-changing and complex. We therefore don't find it appropriate to include a list that the Secretary for Security may consider when exercising this power. I have one more question about this part. That is for Part 7 of the bill. We see powers to extend the detention period, impose movement restriction on the suspects, and the provision of funds to the suspect, etc. There are also relevant provisions on the amendments to the Criminal Procedure Ordinance, such as the period of remand in a committal proceeding not exceeding 8 days. There'll be a change. Now, I understand that the administration has explained about these provisions, and they have also explained to us how these proposed new powers and procedures tally with what is enshrined in the basic law, such as safeguards, human rights safeguards. So let's just see if the administration would like to give an overall response to all the new powers and the amendments in Part 7 and how they tally with the human rights safeguards in the Basic Law and the HKNSL, such that there is no conflict. Mr. Law. Thank you, Chairman. Thank you, Legal Advisor, for the questions. We've made reference to other jurisdictions, such as the laws in the UK. There are similar provisions. To some extent, these provisions may undermine or restrict the rights and freedoms of the absconders, and that is why our requirements are very stringent. For example, an application should be made to the magistrate for extension of detention of the suspect and for restricting the suspect to consult a lawyer. We believe the court will be the best gatekeeper. We also impose very stringent requirements. Only when these harsh conditions are met will the court give its approval. And this need should be reviewed on a regular basis. If there ceases to be such a need, the restriction should be removed. For example, on supporting absconders, we provide a discretionary power, but the power is only to be exercised after considering whether there is a need to safeguard national security. And when exercising this power, it must be reasonable and proportionate. We believe the design of this bill is consistent with the basic law and the HKNSL and the human rights safeguards therein. And in enforcing the law law enforcement agencies will ensure that powers are exercised only when without conflicting the basic law and HKNSL. It is important to provide human rights safeguards, so a proper balance should be struck. The human rights safeguards are provided in the basic law, the HKNSL, and the two international covenants. In fact, Annex F in the LegCo brief relates to the relationship between the bill and the international human rights conventions. This paper explains how we have struck a balance between the two. SJ, as this is a very important and core issue close to the heart of the public, I'd also like to add to what my colleagues have said. And that is to say, no unreasonable restriction will be imposed through this bill. Now, the paramount principle is that the human rights may be restricted on the premise of safeguarding national security. One condition to be met is that it must be reasonable. And in deciding on the point of reasonableness, we need to consider three things. First, the grounds for imposing a restriction. I would say we want to extend the detention period, and the reason is that there is reason to believe that this suspect may destroy evidence or may tip off other offenders. These are matters relating to safeguarding national security. There is a causal link. This is the only reason, and we don't accept other reasons. It's not because if we detain the suspect longer, the suspect may confess. There must be a direct causal link between the prohibition and safeguarding national security. The second point is proportionality, and the extent. For example, if we extend the detention period, it should be not more than 14 days. It's extended on a need basis. And when I've completed the investigation, I should tell the court immediately and remove this extension order. So the extent of prohibition should not go beyond what is necessary in safeguarding national security. It should be put to a minimum, such that the only ground is to safeguard national security. The third point is gatekeeping. How do we make sure that the law enforcement agency is duly fulfilling the duty and exercising the power properly? That's why we have an additional safeguard. There is judicial independence. It's for the judiciary to be the gatekeeper. We need to show proof to the court that there is a reasonable ground. There is a genuine need to do so. And in the context of the case, it's not our own subjective judgment that it is necessary. It's for the court to be satisfied that there is a need to do so. And only when the court is satisfied will the prohibition take effect. So the reason for imposing the prohibition, the extent of prohibition, as well as gatekeeping, it's for the court as an independent body, as the gatekeeper, to decide. So taking everything as a whole, we believe the whole mechanism will help us align with international human rights standards. Anything to add? No follow-up and no other questions. Thank you, Chairman. Any follow-up questions on the administration's reply? If not, my question for the legal advisor is this. Any questions on the drafting aspect of the bill as well as the Chinese vis-a-vis the English renditions? We confirm that the English rendition is free of errors. So we have completed the clause-by-clause scrutiny. We've completed this step. I want to remind members that if you wish to make amendment to the bill, please submit the proposed amendment to the Secretariat before 5 p.m. this afternoon. The administration will respond to any proposed amendment from members if need be. Do you need more time? Well, I think the meeting is getting longer than expected. Do you need more time to consider the amendments since the legal advisor has just made a number of points? So if you need more time, do tell us. Chairman, basically, we have prepared the Chinese version of the amendments. It will take some time to prepare the English text as well. Which way should we go? Let me talk to the clerk.
Hi.
How about this? If you only provide the Chinese text and not the English text, I don't think you've completed this step. You will only have completed this step when you've submitted both languages. The amendments in both languages. So how about handing them in before 9 tonight? Both Chinese and English versions. LDD, Law Drafting Division, any problems? We'll do our best. How about before 12? The Secretariat may need time to go through them as well. Right, so be it, because at 9 a.m. tomorrow, we will be discussing the CSAs. Now, if you hand them in early to the Secretariat, the CSAs can be passed on to members earlier, and members should read them through before the meeting begins. So it'd be best if you could submit both Chinese and English versions of the CSA to the Secretariat by 9 p.m. All right? No problem? Okay. Before 9 p.m. then. So we've completed clause-by-clause scrutiny. We can wrap up item 1 of the agenda. Item 2, AOB, nothing under AOB. I'd like to inform members that another meeting is scheduled for 4:40. This will be cancelled. And then for tomorrow, have you issued a notice? Well, a notice will be issued. Another meeting will be held in room 1 at 9 a.m. tomorrow. In fact, there are 2 sessions scheduled. I hope there'll be enough time. Otherwise, more meetings will be held in the afternoon. So far, we haven't scheduled a meeting in the afternoon, but do make sure you have time for that. If we're not able to complete the scrutiny in the morning, we may need to have afternoon meetings. Thank you.
可以擺喺度，係會鎖門。
We'll lock the door.